Well, good morning, everyone. Thank you for joining us. This is the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy. I'm an attorney at Sheehan Finney Bass and Green, and Sheehan Finney is a host of this program. I'm thrilled to be joined today by my partner, Karen Whitley, who's going to be talking to you about issues to consider when updating your handbook, your employee handbook, now that we're in a post-pandemic period, and some of the things to consider. But first, I want to welcome you all being here on this Wednesday morning. I know time is precious, especially this time of year, so we'll get to the program pretty quickly. But in the meantime, just a quick preview. Next month, December 13th, is our annual Wage and Hour Top 10 violations and how to avoid them. In January, kicking off the new year, 2024, if you can believe it, financial wellness, do's and don'ts when investing in retirement. So it's both individual and perhaps on an employer basis programs to offer your employees. And in February, the month of Valentine's Day, given the numbers that we've been seeing from our friends at EEOC, the issue of dealing with investigating and dealing with sex harassment in the age of remote work. Interesting topic, and we're certainly going to be there'll be lots of information to share. Speaking of information to share, at the very end of the program, you're going to see a slide that has information on the HR code for attending this program. That will also be emailed to you along with a link to the recording for this program and the materials themselves. So we are frequently asked a question about the HR code and so on, and sharing the information and so on. Not to worry, Liz Tezik from our marketing department will be sending that along at the end of the program. So to avoid wasting any more of your precious time, I'm going to turn it back to Karen Whitley to talk to you about updating your handbook, your employee handbook. Take it away, Karen.
Thank you, Jim, and good morning, everybody. So our favorite topic of the day, updating your handbook. And clearly this is a topic that did not receive as much attention maybe as it otherwise would have over the past 3 years. Handbook updates were not your most pressing concern while you were figuring out how to keep people healthy and working. But since you maybe dusted off that handbook, laws have changed. There's been a number of changes in leave policies, for example, depending on the state where you are. And workplaces have changed. I think there's no doubt about it that we've seen some flexibility, for example, with remote work. But there's other aspects of your workplaces that may have changed based on lessons that you learned or attitudes towards various practices as a result of the pandemic. So things have changed. And maybe in a good way, you have expanded. So if you now have business operations in different states, again, because of that flexibility, allowing people to work remotely, you may now have to deal with what are the leave laws in Arizona, for example. So now is a really good time to revisit your policies, compare your policies to how you actually are doing things, and get those policies in writing, making sure that they're clear, that they're consistent, and see how COVID might have changed the company's perspective about things and what legal obligations might have changed. So there's a lot to be thinking of, again, as you deal with that reboot. Okay, there we go. So from time to time, we do get the question of whether you need a handbook. And on the whole, I do feel it's an important thing for companies to have. There's some pros and cons, though. Some pros are that it sets the opportunity, it's the opportunity to really set your tone and your expectations. The other piece that is really important is freeing up your HR folks for other tasks. If employees have a place to go for their initial questions, maybe they won't be knocking on your HR manager's door, for example, to ask about a pretty routine question. So sometimes having that handbook is a really good opportunity to just do a little self-help for your employees. And the other pro, or another pro, is that it can really minimize legal claims. We want to be able to point to the handbook to give a reason why a company did or didn't do something. We want to clarify employee expectations. And these are all reasons why it might be a good idea to have a handbook. But there's many cons if you're not addressing your handbook on a routine basis and updating it, or if you're not paying attention to whether there's a discrepancy between how you do things and what the policy says. So there's a number of cons. Boilerplate is often used. We get companies that maybe borrowed the handbook from someone else or got an off-the-shelf version from some legal source, or maybe got it from a payroll company, for example, but didn't take the time to customize it. So boilerplate can be confusing. It might not be user-friendly. It might not be consistent with what you're actually doing. What is reality in your workplace? And it also might not be user-friendly for whatever reason. It could be disorganized. There might not be a table of contents. It might be difficult for people to find things. So using boilerplate without taking that extra step of customizing can be a real negative. It might not be descriptive enough. We get a lot of handbooks to review on a yearly basis, and some of them are very, very high level, and maybe that's good for that particular workplace. But there are some policies that, first of all, you really should have. And then if you kind of gloss over other ones, that can be a problem in the long run. If you say, well, that's how we do things, but everybody knows about it, but there's not a place that it's written down, that can really be a negative. Sometimes they're too descriptive. We've had handbooks that are 95, 100 pages long. It's very unwieldy and difficult maybe for people to find things. It's also a real trap for sort of having inconsistencies. If a handbook says one thing in one place, but on page 85 it says something different, you've created a conflict for yourself that's sometimes difficult to get around. And the other piece, of course, the reason we're here today, handbooks get outdated somewhat quickly. If you haven't kept up with the changes either in the law or in the way your practices work or in the places where your employees work, that employee handbook can be outdated. Changes in the law and company growth are two of the reasons that, again, they become outdated pretty quickly. And everybody knows that putting a handbook as a priority is not sustainable, right? You're always going to get more important immediate emergencies, fires you have to put out that push that employee handbook review really far down the to-do list. And it can be a really big project. It can be daunting. And finally, one of the biggest issues with handbook is that if you are not careful, it can be viewed as a contract. The other thing, I can't tell you how many times we have heard from employers, we have a handbook, but we have another one that's in draft form. And that's where we've clarified some of the stuff. If employees haven't seen the handbook and haven't acknowledged it, you're not going to be able to hold them to whatever clarifications you've put in place in a draft. So all of this, from a risk standpoint, can be pretty significant. A handbook is often one of the first places that a lawyer for an employee will look to see what does the company's policy say. If a policy is incomplete or vague or non-existent, that lawyer for that employee might come into a negotiation with a little bit more feeling of power and strength because of what your handbook does or does not say. So just want to talk for a few minutes about the different parts of a handbook. So first, the overview or the introduction section. This is really a place for you to define your mission and values. And I talked earlier about the importance of customizing. And this is a place to do that. Some companies, especially family-owned or ones with an interesting history, will talk a little bit about that history. Again, to act as a real way of having people feel that they are part of that company, that they're part of that family. And it's a really good opportunity to communicate the values and the mission and the history in a way that has people feeling included right from the very start. The other piece is that it's a very critical tool for setting the tone within an organization. It also helps to think about how you want to personalize. In other words, are you saying employees shall do this, employees must do this? Or are you trying to speak directly to your employees? You should ask HR if you have this question. If this happens, you should do X. So you need to figure out how you want to communicate, how formal you want it to be, and how much of, how off-putting it might be if it is filled with employees shall, employees must. Again, a lot of that is important, but you want to think about how you want to communicate that. I always suggest, especially if it's longer than 20 or so, 30 pages, to put it in a table of contents. That really, again, cuts down on the amount of time employees spend flipping and giving up on trying to find a particular policy. So if you can put in that table of contents, it just adds to the ease of communication. Overall, really, it is in a handbook, not just what you say, but how you say it. And this overview really sets the tone. The other thing on the issue of communication is more and more companies need to be thinking about the use of pronouns. And this is an additional communication piece. The handbook itself can show an employer's mindset towards being inclusive. Does it say an employee must do this and he should do X? Or is there an attention being paid to the use of pronouns? The next important piece is the disclaimer section. And disclaimers are found both in the introduction beginning section, as well as in the acknowledgement form. And I make sure that those disclaimers that we'll talk about are in both places. So contractual disclaimers are key. And what I mean by that is, as I said earlier, one of the cons is that sometimes employee handbooks are put up as a contract between an employer and an employee. And you do not want it to be a contract. You want it to be a guide. You want this handbook to provide information, but not be a binding contract with any particular employee. So there should be an express disclaimer that the handbook is not a contract, either express or implied. It's a guide. It cannot cover every situation. Everybody knows there'll be a new situation that comes through your door today that you haven't anticipated. So a handbook cannot cover everything, and therefore you can't have it be a contract that you will treat a certain situation in a certain way. Importantly, a handbook should not guarantee a job for any particular period of time. So the idea of employment being at will is one that should be emphasized in at least two different places, at the beginning and at the end in the acknowledgement form. So the fact that employment is at will, that means that the employee or the employer can end employment at any time for any lawful reason, and that nothing in the handbook is intended to change that, and that the only way that that changes is if there's a written contract with an authorized company representative that deviates from the at-will arrangement. The disclaimer should also show that or say that policies should be changed or withdrawn, can be changed or withdrawn at any time by the employer, and that employees will be notified of those changes. And finally, and this has come up in some recent case law that we'll go over at the towards the end of today's presentation, that a handbook that is issued and is updated supersedes prior versions of the handbook. So moving on to another meaty section of each handbook is the equal employment opportunity policy. So this policy should confirm a company's commitment to the principles of equal employment without regard to an employee's legally protected characteristics. So a decision point for employers will be how do you explain to employees what characteristics are protected? There may be different characteristics that are protected under federal law and state laws. State laws are often further down the road on this in this regard. And so you want to understand that there may be a long list of protected characteristics, but in a particular state, there may be additional characteristics that are protected. These are characteristics that, where the laws on these characteristics change from time to time. I put up two that changed in the past couple of years. For example, in Massachusetts, the Crown Act protects natural hairstyles, which are traits linked to race. And then recently, the Federal Pregnant Workers Fairness Act was implemented. So there are changes in the law regarding the protections that as an employer you have to provide. So you do want to make sure that your EEO policy is up to date, and you are also including what I call the catch-all phrase. So we protect, we prohibit discrimination, and we provide equal opportunity on the basis of your objective qualifications without regard to race, age, veteran status, pregnancy status, that sort of thing, and all other characteristics protected by federal, state, or local law. So hand in hand with your EEO policy is your anti-discrimination and anti-harassment policy. So the thing to be watching out now in this post-pandemic era are changes with regard to these types of policies. And the EEOC announced in October a draft of an enforcement guidance on harassment in the workplace. So that was proposed, I believe, on October 2nd. The comment period ended at the beginning of November, and so we're expecting this to be finalized. And it is worth a read because it very well could impact the types of things you say in your anti-discrimination and anti-harassment policy in your handbook. So based on the new guidance, a review of your handbook could mean that you should refine the definitions and examples in your sexual harassment policy. It also could mean that you refine and update the definitions and examples of your workplace harassment policy. So I'm seeing less of this now, but it used to be the anti-discrimination and anti-harassment policy was pretty much focused on sexual harassment. Over the past 5 or so years, I've seen more companies that are recognizing that the harassment policy needs to cover sexual harassment, but also workplace harassment, harassment based on race, disability, age, all the other protected characteristics. So those discrimination and harassment based on those characteristics are prohibited. But I often see examples of what sexual harassment is and no examples of what other types of workplace harassment are. So this is an opportunity to look at the proposed guidance and understand and to incorporate some of the examples, very helpful examples, I think, that EEOC and guidance includes. So your workplace harassment section should not just say that we prohibit comments or stereotypes about someone's race, but recognize that the EEOC is going to be looking very carefully to see whether there was harassment that was based on other traits that might be linked to race. So making fun of somebody's ethnic sounding name or their cultural dress, their accent, the way that their particular religion or national origin encourages certain types of grooming. So the EEO guidance, again, is a helpful place to look for some examples to see whether you need to incorporate some of those into your handbook. The proposed guidance also talks about best practices for harassment policies. And so in that light, you want to make sure that your harassment policy, any updates, you may have it separate from your handbook, but if it's included in your handbook, that it is widely disseminated. And so you may be updating or redistributing your harassment policy annually, for example. You want to be able to show that you've done that. And for a handbook, you want to be able to show that the updates have gone out to folks with any changes to your harassment policy, and that they've acknowledged receipt. Another best practice that's set out in this proposed guidance is to make sure that your harassment policy is understandable. And for that, it means, it's not only filled with legalese, but it's written in a way that folks can understand. And in particular, that it's accessible to people with limited proficiency in English. So that may mean either it runs through a Google Translate tool, or you actually have a handbook prepared by a professional translator for the languages that are most prominent in your workplace. Additionally, another best practice is to include multiple ways to report harassment. And that might mean not only that you give the names of several people who can accept those reports of harassment, but you give multiple ways to contact them. And again, in this post-pandemic era, think, well, is our HR person or this other person who's designated as the person to receive complaints, is that person in the office every day? Is there a reliable way to reach them if somebody has a complaint like this or a concern like this? Do you want to set up some sort of email address that will alert a couple of people at the same time if somebody raises a concern like this? So be thinking about how you're getting this information across. Another thing that I recommend including in the area of your anti-discrimination, anti-harassment policy is a reminder that even if some conduct does not rise to the level of harassment, that the company still could take some discipline based on the nature of the conduct, maybe being unprofessional or inconsistent with your values, even if it's not, quote, legal harassment. I also recommend having a separate anti-retaliation section. I sometimes see a discussion of harassment and it's, a long discussion of what sexual harassment is, maybe a shorter discussion of what workplace harassment is, and then a one-liner. The company also prohibits retaliation against somebody who makes these complaints. But I think calling it out, having it be a separate section, at least a separate paragraph, maybe with a header, reinforces the importance that an employer should be placing on the anti-retaliation policy. Because the truth of the matter is harassment claims are somewhat difficult to prove, maybe difficult to prove. There's maybe a he said, she said element to it. Retaliation claims are one of the, those types of claims are potentially easier to prove. And you can see that if you look at the statistics of how many cases include an anti-retaliation, a violation of an anti-retaliation policy component. So understand that it is a separate claim. It is a very popular claim, and it deserves its own, at least its own paragraph. But I will say it's not just anti-retaliation in the context of harassment or discrimination. It is also important to emphasize in other places in your handbook that you do not condone retaliation if employees take other types of protected actions. So if an employee asks for flexible working hours in New Hampshire, there's a specific legal provision saying that the employee will not be retaliated against for making that request. The employer doesn't have to grant that request, but the employer cannot retaliate. Also, just reminding employees that there's no retaliation for making a good faith complaint about safety or other types of legal violations, or if they exercise legal rights. So it is helpful, again, to have that in there. And again, some employers might say, that's a little dicey for us. We're concerned about putting some language that says, hey, you can raise this type of a complaint or a claim against us. But this handbook is very important both for employees and managers to understand. So anybody who's in a position of being able to retaliate against somebody should understand the importance of these anti-retaliation policies, and emphasizing them in a handbook is always, it's a best practice, I would say. Reasonable accommodation policies are policies that have gotten a very fair share of attention during the pandemic, both because people were saying, I can't be in the office because of a health issue or a mental health issue, and then because of the vaccine requirements. So this is an area that it is really worth looking at and seeing, can you beef up what you've written? I will say that many reasonable accommodation policies and handbooks stop after the first bullet here, so that the company describes its commitment to give a reasonable workplace accommodation for qualified disabled employees. And I see it stop there. So when I'm revising handbooks, I'm often adding in these other two areas where it's very clear from a legal standpoint that employers are supposed to be providing reasonable accommodations. So number one is for pregnancy and related conditions, including lactation and breastfeeding, but additionally for sincerely held religious beliefs. And then all of those reasons that an employer might give a reasonable accommodation should be part of the discussion of an interactive process. So sometimes employers will say, we give reasonable accommodation for these things, but then they'll only talk about the medical information that might be needed for a reasonable accommodation with regard to a disability. I see a couple questions. I just want to okay, whoops. All right, so I think those questions will be addressed later. Okay, so now moving on to employment classifications. I have gone through handbooks and read them and said, wow, these are really complete. These are great. They cover all the bases in terms of the policies, but there's no description of who the policies apply to or whether the policies are different for different categories of employees. And so it's important to take a step back and recognize that there may be policies that are different for different categories of employees. And for example, if you're discussing overtime policies don't apply to your exempt workers. And I'll just say that, as an aside, you should be paying attention to possible upcoming changes in the rules about exempt employees and what employees can be considered exempt. As you may be aware, there's regulatory action in the works to raise the salary threshold from its current $684 a week to a higher number, and also to put in place a system where that salary threshold, and you need to meet the salary threshold and have certain duties in order for someone to be considered exempt. There's a process in place, the process being considered where this salary threshold might be increased on an annual basis. So I am not recommending that you put in what the salary number is in your handbook, because you may just have to change that on an annual basis. But I will say that there is going to be, if these rules take effect, a pretty significant jump in the salary that you have to pay somebody in order for them to be exempt. So you're going to have to think about the fact that there might be employees who are currently considered exempt that may fall below that salary threshold and may need to be treat them as non-exempt workers. So they may all of a sudden be subject to your overtime rules. So it is helpful to describe the different categories that you have. And that basically comes down to talking about your exempt versus non-exempt classification. Is somebody exempt from overtime or not exempt from overtime? And then also talking about how you treat them in terms of full-time, part-time, seasonal, temporary, per diem. Because These categories matter often when it comes to benefits, but you do need to make a good effort to describe what benefits would apply to each category. So, for example, you can't just say our full-time people get this, our part-time people get this. And then if you have a temporary or an intern or a per diem person and you don't mention anything about where they fall, you might be overlooking the fact that at least in some states, and for example, Massachusetts has the earned sick time law that says that even temporary employees, interns, per diem employees would be eligible to be accruing earned sick time. So you want to be thinking about where your employees fall. Do they know where they fall? Do they have a place to look to see how their role is defined? You also want to spend a good amount of time on your payroll policies, at least just checking the boxes about what your particular state requires. For example, in New Hampshire, you have to identify for workers their pay dates and your pay practices and whether they're entitled to pay time off or other benefits. You don't necessarily need to do that in your handbook if it is different for different folks, but it's a great place to have a baseline. Our work week or our pay period is from Sunday to Saturday. We pay on the following Thursday, for example. You do want to also include some requirements, again, keeping in mind that this is not a contract, but your expectations will be that people will get a pre-approval, if this is true, before they do overtime work. You also want to include what's known as a safe harbor under the Fair Labor Standards Act. So, for example, there could be an issue where an exempt employee has a deduction made from their salary and it was not authorized, or it was not proper. And if that happens, that could jeopardize that person's status as an exempt employee. But if you have a safe harbor, or if you follow this, you can put this language in your handbook, say, as soon as we figured this out, we changed it. We told people that if they had an issue with their paycheck, they should come to us, and we made an immediate change. You will potentially be able to save that person's exempt status. So it's a good idea just to include this language to alert exempt employees in particular that if there's any issue with their pay, they should come forward. And it's a way of making sure that any mistakes don't trip you up. Just a couple of other types of policies you may want to have. If you have people showing up for just a couple of hours a day, you need to understand that you have to pay them, putting in something about reporting pay, putting in something about mileage, and putting in something about expense reimbursement. Now, expense reimbursement may be something that has changed on your end during COVID because of the fact that people are working from home or maybe working from home. Did you change the types and amounts of expenses that you would reimburse for people in terms of internet or phone, for example? So be looking at that and any changes that might have happened that didn't, your handbook is a little behind the times on that. Leave policies is one of the more complex areas in your handbook because there could be so many different types, and the landscape from a legal perspective is constantly changing. If you have employees in many states, this is going to be an area that keeps you up at night because there are so many changes, and the overlap and the interconnection between what you are offering people in some states versus other states, how that interacts with your actual policies, all of that's going to need to be very carefully reviewed. So you want to think about how all of these leave policies overlap, how they supplement each other, and find a way to explain that as clearly as possible. Sometimes employers will put a very general description. We have this, we have parental leave, we have family medical leave, we have all of these types of leaves, and here is a summary, but speak to HR about your specific circumstances. And again, that may be the best use of your HR department's time, is to have the actual facts in front of you and have the legal requirements in front of you, rather than explaining this all in a handbook. But you, from the FMLA's perspective, you have to have a description of what the FMLA is. You should have your policies written down here so that employees can look for themselves. But again, this is an area where if there are changes, this is probably going to be the most common area for updates needed and the most area for confusion of your employees. Now, benefits change, certain benefits, probably on an annual basis. So if you're talking about insurance, health, medical, vision, dental, those types of things could change on an annual basis. So from that perspective, I don't recommend having a detailed description of your benefits, those types of benefits in your handbook. Instead, you can outline the categories of benefits that you offer and then refer to the formal summary plan description and to HR or to any intranet page that you might have. But from the insurance perspective, it doesn't make sense to have that be a detailed explanation in your handbook. Now, from the vacation and holiday personal floating sick time, again, this is an area where it's good to have it written down. It might be legally required to have it written down. It's a great place to have people be able to refer back to it themselves. But it also may be an area where attitudes changed during COVID. Perhaps people were able to use vacation time to cover absences that they really were sick time. So maybe without the requisite advance notice, right? So maybe before you said to use vacation time, you have to give 2 weeks notice. Maybe during COVID, because of the types of absences people were having, they had to do quarantining, they had to stay home because of a sick family member. Perhaps that changed and your attitudes about these policies might have changed. So you do want to take a look and see whether your policies match reality. And you want to have a place where people can refer to about how is this accrued, accrual rate, lump sum. What happens if it's, I get more vacation after I've been here 3 years? Well, what if my 3 years happens in the middle of a year? How do I know when that accrual starts? Importantly, including your notice requirements, your record keeper requirements, and your purposes for leave in your handbook is a good use of that space, as well as carryover and payout. Now, another section of a handbook, a pretty standard part, would be what I call the terms of work section. So that really talks about, how do we do our work? How do we keep up with, with each other? How do we know how we're going to get paid and that sort of thing? So you should include your call-in policies. What are your core hours of work? Especially in a remote and hybrid work environment, that may have changed. So you want to make sure that that's very clearly stated. Introductory period is something a lot of employers have, but I always put a qualifier there that you can have an introductory period, 30, 60, 90 days, but you want to make clear that if somebody satisfies that introductory period and is still working on day 91, for example, that they are still an at-will employee. It doesn't change the at-will nature of employment. So introductory period probably hasn't had much impact during COVID. The call-in policies, the core hours of work, that very well may have had some changes during COVID. Timekeeping and attendance. Do you require all employees to record their time? Do you just have non-exempt employees record their time, and then exempt workers just have to record if they took a full day off, for example? Rest and meal periods, another easy place to put that information and have employees be able to refer to that as opposed to talking to HR. Flexible hours. What, if any, changes have been made to your flexible hour policy? As I mentioned earlier, in New Hampshire, you can't retaliate against an employee who asks for flexible hours, even though you don't have to give those, give into that request. I want to just take a quick pause to see. Okay, rest and meal periods. Somebody actually has a question about prayer breaks. So do I have to pay for an employee to pray during the day? So under the Fair Labor Standards Act, employees who take a break of less than 20 minutes are entitled to be paid for that. So you cannot deduct for a break of less than 20 minutes. So if an employee has a break and uses that and it's under 20 minutes, you do have to pay them for that. It is a paid break. So I want to make sure that I said that correctly. I may have said it backwards. 20-minute breaks or less are paid. So if an employee uses that break for prayer, they can be paid. Now the question may be, do I have to give a break for prayer? And I would say that is part of the reasonable accommodation dialogue. Is there a reason that employee, for an undue hardship reason, is there a reason that employee cannot be provided the time to pray? Again, that gets into a whole different webinar, but I will just say that from a handbook perspective, if your employee handbook talks about you giving a reasonable accommodation for sincerely held religious beliefs, a conversation about praying for prayer breaks would be included in that discussion. Okay. Someone asked a question. I had put a leave Veterans and Memorial Day. There are specific requirements about allowing veterans time off to attend certain veterans appreciation or recognition activities. So I can certainly speak to that offline, but there are requirements in Massachusetts for those. So I want to keep going in the interest of time, but can circle back to some questions. I see we got a whole bunch coming in at this point. So moving to the area of, the conditions of work that I think has seen one of the most dramatic shifts during COVID is the idea of remote work. So if your workplace is one that was able to successfully move remote, or a good portion of the work was able to be done remotely, at least during the most critical parts of COVID. The question is whether that is remaining. And we've all heard of situations where employees are refusing to come back, either for health reasons or family reasons, or because they can get their work done much more productively at home, and there's really no downside from a work getting done perspective for the employer. But the question is, if you are allowing that, are you putting some parameters in writing? Are you saying we want people back 2 or 3 days a week, or we want people in the office on these core hours? It's a very helpful practice to have whatever your policy is written down so that it can be consistently applied, and you don't have people in one department able to work remotely whenever they want without any notice, and other people being subject to a really rigid schedule. So it is an important conversation to be having. And once you've reached a consensus or decision on how you're going to implement this, you want to have it in writing. Part of some of the criteria or elements you want to be thinking about if you're having a remote work or hybrid workplace, helping employees understand what the process is to ask for that, what the criteria are. That may mean that you need to also look at your job descriptions to see whether a particular job lists that in-person collaboration is an essential function. So that may be tied, the handbook and the job description may be tied in that way. It is clear that not all positions and not all workplaces are appropriate for remote work. But to the extent that an employer agrees that employees can work remote some days of the week, it's important, if it's true, to clarify that it is a privilege that can be taken away if it is abused, or if the nature of the work changes. If remote work is allowed, identifying what the core hours are, and the requirement that someone be available or responsive. Now, some of this can be put in a separate agreement, a remote work arrangement, for example, that an employee reviews and signs and has in their personnel file. And that's certainly a way of dealing with it. But if you are putting into place a company-wide policy and you want to set some of those parameters, some of the additional aspects you want to cover are that the employee must have a safe working space. They must have a place where they can conduct business confidentially, where they will not have family members, walking behind them on Teams meetings. Maybe there's some sort of dress code if there's going to be outward-facing, client-facing interactions, but they're in their home. Maybe you want to require a certain platform like a Zoom or a Teams. Maybe they have to have your company logo behind them. And so all of those things, again, think about the level of detail and balance that against, as I said, some handbooks are 100 pages long, and that seems a little bit unwieldy. So think about what your real issues are with the remote work arrangement and what you really want to convey on a blanket basis, and then include that in a policy. Remote work as an accommodation is really a hot button. It is an area, where maybe people who had wanted to work remotely before COVID were not allowed to. Then during COVID, they were. And now if they're being asked to return to work, they're saying, look, I did my work perfectly fine. Everything went great. How come you're making me come back? Again, this goes back to the job descriptions and the requirements of a job and what are the essential functions. Keeping in mind that an employer does not have to eliminate an essential function as part of an accommodation, but the EEOC does encourage looking to see whether in fact something is now an essential function. If it didn't need to in-person presence during COVID, does it need it now? And the answer may well be yes. An employer may in fact insist upon in-person presence, but you can include in your handbook that remote work may be discussed as a reasonable accommodation, keeping in mind that the employer doesn't have to eliminate an essential job function and that there may be an undue hardship to let that happen. Just a couple of other policies that employers may have: smoking and vaping, your substance-free workplace policy, and what you say about testing, depending on the state that you're in, your social media policy, tuition and education assistance, if that's something that you offer or are considering, violence, weapons, and safety in reporting injuries. At least in every handbook, there should be a statement that any injury, workplace injury or illness, no matter how minor, should be reported to HR or to a safety officer. That should definitely be stated, but you may also have a separate safety handbook with much more detailed requirements. Now, a couple of policies that really have a pretty direct connection to the pandemic, I'd say. We didn't necessarily see infectious disease policies in many handbooks prior to COVID, but that became a reality for a lot of us, and companies did start putting some of those policies in play. And the questions that you have to address and think about for your own workplace are, the ability that folks have to work remotely, even if they are infectious, right? They may be perfectly able to work, but they're coughing. So are you going to allow people to work remotely? Are people able to do that? Are they set up to do that? Are there conditions that you have about their return to work? So potentially putting into place an infectious illness policy is a good idea. We then, of course, dealt with the vaccine requirements and testing and accommodations. That may be something that you want to have a specific policy about. But what I actually had pulled together pretty soon after COVID started and after we started to see the impacts is a workplace flexibility policy that a lot of my clients have adopted. And basically what that was saying was, we learned from COVID that workplaces have to change. They may have to change due to legal requirements. They may have to change for health and safety reasons. And that when somebody has a job and it's an at-will job and they have a certain understanding of what their job looks like, the employer has the discretion to change those requirements and people's duties, the way that they do work, where they do work, how they do their work, whether they're wearing PPE when they do their work. All of those conditions are subject to change, and the employer reserves the right to make those changes. The employer reserves the right to have certain precautions in place. So if you had a temperature above a certain number, you weren't allowed to come to work. And what your requirements are, again, for people coming back. So a policy that doesn't necessarily mention COVID, but sets out a framework where the employer reminds all the employees things may change for reasons beyond our control, or to make sure that we have a safe workplace. And we want to make it sure everybody understands these things may change. We may impose additional requirements. Those requirements may be permanent or temporary. And we may make accommodations, and those accommodations may be permanent or temporary. But all of this to say the employer is the one that's making these decisions. And it's then laid out there kind of as a further example of what at-will employment means. Another type of policy or benefit that came along or that was emphasized during COVID, I think, is your EAP. People were dealing with an awful lot of stress for a lot of reasons, and employers who were able to refer folks to an EAP, I think, found that that was a helpful support. And maybe promoting some wellness plans. For example, people who didn't have to do an hour-and-a-half commute each way found it easier to go to a gym or to at least work out outside. And so the promotion of wellness programs kind of was a good opportunity for employers to remind folks about what opportunities they have and what benefits they might have. I don't know about your workplace, but I think the pets at work policy definitely stemmed out of COVID. People were home with their pets, and I think I read an article, when COVID lets up a little bit and people are able to go back to work, that the pets are going to be depressed. Pets in the workplace may be something that you always allowed, maybe something that you never allowed and never will allow. But, there are some workplaces that are taking a little bit more flexible approach about that. And then, as I mentioned earlier, the reimbursement of additional expenses, because people were working at home and paying for things themselves. And perhaps your workplace has adjusted its view on cell phone and internet reimbursement. So if so, the handbook is a good place to have that. And the other reason to include some of these policies in your handbook is when somebody is first joining and they get this handbook and they're able to see all the things that the employer does to support them and to make life easier for them, or gives them additional benefits. It's a nice little package to give to them as well. Let's see, before I go a little bit further, let's just say, There's a question here. In New Hampshire, does the law say that any earned PTO needs to be paid out upon leaving the company? Currently, no. Currently, the law says if, in New Hampshire, if your policy says that you will pay it out, you have to follow your policy. But at the moment, although I think there's a move legislatively to change this, at the moment, if your policy says that you don't pay out accrued PTO in New Hampshire, you don't have to. That's different in Massachusetts and in some other states. Going back to this introductory period or probationary period, many managers are used to using intro periods as probationary period and feel it is easier to terminate during this time. I would say I agree with that is the mentality, that people feel that it is easier. And it may well be that because the employee has an understanding it's probationary, the employer feels that the employee will have less of a basis to complain. And maybe that is kind of emotionally true, but there is, from day one, if there's an understanding that it's at will employment, there's really no greater or lesser right to terminate day 2 versus day 92. And as I said, even if an employee completes that probationary period and goes into the regular employment period, they're still employees at will, and there's no greater right to employment then. Remote work, can we require childcare during the workday for remote workers? So I would say that that's a important aspect to build into either your handbook policy, or if you have a separate remote work policy or remote work arrangement or agreement that somebody signs, that the remote work is not intended to be a substitute for childcare or for other family responsibilities. And that's, goes hand in hand with the understanding that people need to be available during their core hours and be accessible and be able to jump on calls, etc. So if you're emphasizing, we still expect the same output, production, responsiveness from you when you're at home, you're just changing the location of where you work. And then build that with this is not intended to be a daycare substitute. Whether you can require someone to get childcare, I don't know that I would say it in that way, but certainly say it is not a substitute for that. So jumping on to the company property section, often this is there's some parts of this that would be covered in an offer letter. For example, we're going to give you equipment and we expect it to come back at the end of employment. But it is a helpful place to summarize what your expectations are about company property and information in your handbook. So making clear that the use of property and technology and vehicles doesn't give the employee any ownership rights, right? It is company property. Whatever is done, especially on company technology, belongs to the company and it's not private. You want to make sure that employees understand that the information that they learn and gain access to during their employment is confidential to that may be confidential to the employer, has to be maintained as confidential. There are some nuances to that. But the biggest piece of it is to make sure, again, this is not a contract. Your handbook is not supposed to be a contract. So if you give your employees a handbook and they acknowledge it, and it says you have to keep the confidential information we give you as confidential, and that's all you give them, you don't have a contract with them where you can say they breached their contract when they gave their next door neighbor your pricing list. You want to have a separate contractual confidentiality or non-disclosure agreement, right? Because you don't want the handbook to be a contract that can be held against you. If you want to hold an employee responsible for protection of your confidential information, a separate contract can be simple one-pager, that they sign at the beginning of employment and they're reminded of when they leave is the best way to do that. On the company property and information area, you want to make sure that to the extent people are driving for you, you want to make sure they're reminded of hands-free driving. Again, the personal use of phones, electronic systems, social media, and email, all of that belongs to the employer, and the employees should have no expectation of privacy. And one of the ways that you can show that they have no expectation of privacy is if you put in your handbook that they should have no expectation of privacy. The return of property at termination, again, it's often something that's in an offer letter or an employment agreement. The Defend Trade Secrets Act is something that often shows up in separation agreements, but there's no harm in putting it in your handbook. And it basically says, even though you have to hold our information confidential, there are exceptions where you need to disclose that with report of some sort of legal violation. And the Defend Trade Secrets Act provides employees the protection that they can share that information with immunity, but also gives the employer the benefit that if somebody shares information that is not necessary for the report of a legal violation, that they can be held liable for multiple damages. So including some language on the DTSA can actually be a win-win. Disciplinary policies, I see the gamut in handbooks. Some say very little, and some give a page and a half long of all the different types of things that can be the subject of discipline, or a code of conduct. But it's a very good way to convey your expectations. The trick is to make sure that you're not saying these are the only reasons we can terminate you immediately, but to say here are some examples. Again, it's at-will employment. We can let you go, or you can leave at any time. Here are some examples that you should be aware of that would be a basis for immediate termination or immediate suspension, or would subject you to discipline up to including termination. So be aware of maybe the types of misconduct that you frequently see, and you might want to have those written down depending on your workplace. But make sure that that list, if you include one, are just examples, and that you're not doing anything to say these are the only reasons we can let you go, because that could impact whether someone thinks they have at-will employment or not, right? If my employment is safe, except if I do these 15 things, that kind of takes away from the idea that they're at-will employees. Progressive discipline is really important to spell out, meaning because you're at-will employee, we can let you go at any time, but we may take the opportunity to coach you, give you some verbal warnings, and then a written warning, and then maybe suspension, and then termination, because we want to work with you and help you succeed. But we have the discretion to skip the step if we skip any steps, to repeat a step, or to jump right to termination, depending on the circumstances. So laying that out, again, to give people some expectations of what you might do. But you don't want to do that if you're really never going to follow the verbal warning, written warning, suspension path. If you really do, 2 written warnings and then they're out, you want to think carefully about how you, what steps you're promising. I want to speak very quickly about some National Labor Relations Board issues. It's a difficult thing for some non-union workplaces to grasp, that even though they don't have a union, they might be subject to some of these rules. But that is a definitely clear message that the National Labor Relations Board is sending. And it has been sending for many years. So I include in handbooks a disclaimer that the policies don't limit the rights that employees have under the National Labor Relations Act to engage in or participate in or refrain from participating in certain concerted activities. And what I mean generally is talking about wages, talking about the terms and conditions of their employment. So I include a disclaimer like that generally, but there are certain places in a handbook where you want to just maybe remind people that you're not going to interpret this policy in a way that limits their rights, that any rights that they may have under the National Labor Relations Act. When you are looking at your handbook, you want to make sure that you have in mind what the current state of the National Labor Relations Board is on certain policies. And this has been the subject of a lot of flip-flopping over the past several years. So several years ago, I think 2018, the General Counsel of the National Labor Relations Board put out a memo that talked about their attitude. It's the attitude on letting employees use email or forbidding them from using their company email for personal use. Confidentiality, social media. So there's a variety of topics that the National Labor Relations Board is focused on, and they are focused in particular on what the employer is saying in its handbook about what an employee can and cannot do. So the most recent, as far as I'm aware, in August 2023, a rule was put out in a case by the National Labor Relations Board saying that a workplace rule is presumptively unlawful if it has a reasonable tendency to chill employees from exercising their rights. So if this particular policy and the way it's written in a handbook would stop an employee from exercising its rights, stop an employee from talking about wages or complaining about terms and conditions of employment, it is presumptively unlawful unless the employer can show that the rule has a legitimate and substantial business interest, and that a narrower rule won't work. So I don't have an example of this at this moment. This is something that deserves a larger conversation. But what I can say is you need to be cognizant of the fact that if you lay down the law in your handbook and you interpret it very rigidly without paying attention to whether the National Labor Relations Board or other laws might require that you be a little softer, or that you be able to articulate a reasonable, legitimate business interest that you have to enforce that rule, you might be walking into trouble. So be looking out for your very hard line stance on employees who are voicing their concerns about certain policies or certain practices within the workplace. So talking now the end of employment in your handbook, it's a good place to put some of the expectations that the employer has. Are employees expected to give advance notice? Are they expected to have an exit interview? What happens to their company property? Are they paid any severance? You know, some companies do have a severance plan where if somebody gives a certain amount of notice and has been employed for a certain amount of time, that there might be some pay on separation that they receive. And then dealing with the payout of vacation or PTO, again, that can be something that is dealt with in the handbook, and it might be different from what the law requires. Excuse me. So now I've talked about a lot of the different policies that you might find within a handbook and how COVID has potentially impacted the way you approach certain policies or some additional things you want to be considering when you're updating your policy. Now talking about the actual formatting and updating of handbooks, which I think is an important aspect of this. Because again, if people maybe aren't in the office all the time, or if you're finding that you're making a lot of changes, maybe having a paper handbook versus electronic is not the best option. Or maybe you hand a paper handbook out and you get the written acknowledgement back in paper, but then any subsequent updates for that employee are electronic. So you've got to figure out the format that you're going to use. But you absolutely want to make sure that you received a signed acknowledgement form, hard copy or digitally that you can prove that they signed it. And then any updates, you want to make sure that you're able to track that somebody received and acknowledged an update. How are you pushing out those updates? Are you sending out an email saying, go to our intranet and there's an updated version? Or are you sending out the handbook electronically or in hard copy to folks? And how often are you doing that? Are you taking a good look every other year or every 3 years? Every year? I mean, we have some clients that do that every year. But that is largely dependent on the number of states that they're in because of the number of changes that happen. Acknowledging receipt of changes, again, is going to be very important if you're ever faced with a situation where someone says, well, the handbook that I have from my first week of work says, that I would get paid out for vacation time. And you can't prove that in 2012 you took that away and now I don't. So you do want to have the acknowledgement of receipt. Just a couple of cases that I think help highlight that handbooks are still very much in play in litigation. So it's an important communication tool internally, but employers find that those documents, those handbooks are still potentially a headache for them when it comes to litigation. So in two cases from 2023, a handbook had a good amount of airtime during a trial. So in the Lieber case, there were several handbook issues. One was whether the subsequent handbook changed a pre-existing vacation accrual or rollover policy. So again, how can you prove that the person who thought they were getting a rollover or thought that they were accruing at a certain rate, but then the company changed that for a business reason? How do you prove that they actually got notice of that? And then the other issue in the case was whether the timing of a decision to change the handbook to say that managers could not give references for people who reported to them, whether that was retaliatory. So if somebody left and then right after that, the company put in place a policy that said nobody else can give a reference other than HR, was that retaliatory towards the person who left and who was not able to get a good reference from their manager? Another case, Casey versus St. Mary's, the court dismissed a breach of contract claim where the employee claimed that there was a military leave policy and an anti-discrimination policy, and the employer had not paid the difference between the person's military pay and their regular pay. And the court dismissed the case because the employer had included a clear disclaimer in their handbook that said this is not a contract, and specifically, it's not a contract to pay any type of compensation. So not only does this case show that it's important to have that disclaimer that the employee handbook is not a contract, but also to say it's not a contract in a couple of different ways. It's not a contract generally, it's not a contract for employment at any specific period of time, but also that it was not a contract to pay any particular level of compensation. And so for that reason, the court dismissed the case. But these cases have been going on for a long time. I have a couple of earlier cases, a 2012 case where the employee sued for breach of contract and the employer hadn't allegedly followed the policy in the handbook. But the court agreed the employee was at will. They had no contractual right to enforce the policies. And the fact that there was a disclaimer on each page of the online manual, I mean, that's not hard to include, right? Just the footer, that prevented the policies from becoming contractual. A couple more from several years ago where an employee claimed she was wrongfully terminated in violation of public policy. because she said the company didn't follow its own disciplinary procedures. And the company said that was not a public policy. So she was saying, it's a public policy for the employer to have to honor its commitment to me. And the court said that's not a public policy, that's an internal matter. So those are, again, reasons why the disclaimer is helpful and could help short circuit a case if an employer finds itself in a dispute with an employee. I want to just spend a couple of minutes on multi-state employers, because I know many of the clients we work with either had places of business in other states, and so have been dealing with this for a while, or found themselves with employees working in different states, and they've allowed those employees to continue even after the pandemic is over. And the important thing to remember is that one size does not fit all, generally, because the state laws can have so many variations. So you want to make sure that if you are your employees are in states which have different requirements, different leave requirements, leave obligations, different employee rights, that you are figuring out how you want to deal with that. And there's several ways to put a handbook together to make that the most compliant document for a particular employee. One option is to figure out what is the greatest, most generous list of rights that an employee has. If an employee works in Georgia and a different employee works in California and a different employee works in Maine, can you raise all employees to get the same level of benefit across all of those states? If that's possible, then maybe your handbook takes the best, most generous policy from every state and applies it to everybody. I don't know how realistic that is, because some employees will live in states where it's a state required program. So mass paid family medical leave, you can't give those rights to somebody in Maine because the state of Massachusetts is not going to pay them. But if you can find a way to sort of raise, you raise the tide and everybody gets the best benefits, that regardless of the state that they work in, that's one way to do it. Another is to do a general basic handbook that covers most of the policies that cover everybody, but then do a state specific appendix. And so the employees who work in New Hampshire and Maine and California and Georgia will all have will be able to look at the appendix and see what applies to them in their particular state. So you have the sort of the common denominator and then a state specific appendix. You could include all of those state specific requirements within the body of a handbook. I think that gets a little unwieldy. If you have, here's our parental leave policy, but if you're in Maine, if you're in California, if you're, that tends to get very long and disrupts the flow of the handbook. So I typically do the state specific handbook approach. Or you can give a different handbook that is distributed on a state by state basis. And in that regard, you could either do one handbook that has the state specific requirements built in and you hand it to that, give it to that employee, or you do the common denominator approach with everything that applies to everybody, and then just that particular employee's state appendix. So it's a matter of how complicated your handbook is, what states you're in, what your attitude is towards the various policies and how they might conflict somewhat. But I've seen employers do each of these things and they find the best option that works for them. So after you have a handbook, you're going to want to make sure that you're training your managers on these policies, right? Just putting it out there and letting it ride without giving people direction on how to use it is not going to benefit you. So you do want to make sure that there's training on at least the policies that apply to specific folks. And that can be part of your, for example, harassment and discrimination training. If you do that on a routine basis, that training should draw from the harassment and discrimination policy in your handbook. So you are training to that. But there may be other policies that you train to once you've put them out in your handbook. You also want to make sure that those policies are enforced consistently. You can't, as I said, have one department doing one thing and a different department with a different manager doing something else if your policy says the way that something should be done. Update regularly or when the laws change or when you need to because you now have a group of people, for example, who work in a different state, and you need to do more than just give them a particular or explain to them how it works for them in their state. You may want to embody that state's laws in your handbook in some way. So just a couple of takeaways before we close this morning. If you do not have a handbook, and some employers don't and don't want to or are too small to invest that effort, you at least want to make sure that you display the required posters that are required by the state where your employees are, that you have offer letters that clearly state that the employment is at will, and that if there are key requirements that you expect, have written policies on that. Maybe that is mostly in job descriptions, but if there are key policies, you definitely want to have them written in some way, even if it's not a formal employee handbook. As I mentioned, an employee can be a really great tool for communicating. So make the tone your own, make sure that it covers what is most important to your workplace and your workplace culture. And just realize, as we've seen in COVID, through COVID and through the pandemic, your workplace isn't static and your handbook shouldn't be either. I think one of the most important things that I've seen over the past couple of years is the tendency of HR not to necessarily handle these updates on its own. So by that, I mean, think about who you have reviewing and updating the handbook. It's going to be HR, absolutely, but it might also be business folks, so that you have both a review for legal and personnel issues, but also operational input. And then from an operational side, you might benefit from having people in different functional areas. So safety and IT, look at your handbook and see if there are things that, again, aren't being done the way that the policy says, or could be clearer, or whether there's things that are being missed altogether. So expanding the scope of people who look at these handbooks can be really important. And what about people from different generations in the workplace? Maybe having them take a look at the handbook and provide comments. And also from a DE&I perspective, I think one of the most instructive things that I saw happen at a workplace in the past couple of years is a company had somebody who was focused only on going through the handbook and looking for places where underrepresented employees might have a problem complying. And they looked at pronouns, they looked at certain requirements about transportation and what other things that the employer assumed everybody would be able to do. And this person was able to point out some changes that needed to be made to make the employee handbook be as inclusive as possible. So all that to say, having people who may be beyond HR look at your handbook can be a really helpful way to make this be the best tool it can be for your workplace. And finally, from a risk management perspective, employees and their lawyers will look at the handbook to support a claim. So make sure that it's complete and up to date and includes the proper disclaimers and discretion. It is just about time. I want to make sure that you have this slide, very important, for the credits While I do that, let me just answer a question or two if I can. I see I have a bunch. But first off, you will receive a copy of the recording and the slides. So that is something we do after all of our presentations. Okay, so some of these are specific scenarios that I really can't address in the course of a seminar, but you have my email address, I believe, kwhitley@sheehan.com. There's a couple, for example, the NLRB disclaimer, definitely reach out to me, and that's not difficult. I can send that to you. So I want to be respectful of time on this. Somebody does ask, what is the best practice for regular updates of handbooks annually or every 3 years? Again, it really depends on your workplace. If you are in New Hampshire and you're not growing beyond New Hampshire and your employees are not working outside of New Hampshire, it does not need to be done annually. There have not been that many significant changes over the past year that would necessitate an update, most likely. However, there's some legislation in the works that could change that regarding vacation pay, for example. So I would say annually is probably not necessary if you are pretty much contained in a state that doesn't have a ton of changes, but it's really going to be driven by what legislative changes happen and whether there are changes in the way that you do business that you need to communicate to everybody. So I am going to call it a day at that point. And again, I appreciate your time and attendance this morning, and thank you all, and have a great rest of your day, and be on the lookout for a copy of our slides.